All rise. The Court of Appeals, Division 1, is now in session.
Thank you. Please be seated. Good morning. We are here today for oral argument in our case number CV17-0771, Chandler versus Chandler Improvement. I'm sure you're familiar, but these proceedings are being recorded, so we'd be grateful if each of you, as you approach the podium, would introduce yourself and introduce your client for the record. Each side is allotted 20 minutes for your argument. The appellant may reserve time as they wish. You are responsible for keeping that time. The clock represents the total amount of time you have remaining. Please keep in mind we've read the briefs, we're familiar with the record, we've conferenced the case, and with that, you may proceed.
Good morning. I'm Francis Slavin. I'm appearing here on behalf of Appellant Chandler Improvement Company. With me today are lawyers from my office, Daniel Slavin, who's seated at the council table, Jessica Dorvanen, and Olin Lenitz. I would like to reserve time, Your Honor, for rebuttal at the end of my comments, if I have any time left. I'm going to focus my comments today solely on the issue of standing. Before you today is a case in which the city of Chandler, pursuant to an agreement with a private landowner, attempts to quiet title to a claim held by a private party, my client Chandler Improvement Company, to an interest in the private landowner's land. The city of Chandler does not have standing to expend public taxpayer funds to benefit private developments. My client does not claim any interest in the public alleys adverse to the city of Chandler. We only claim an interest in the abutting lots. In fact, in our answer to the quiet title complaint that was filed by the city of Chandler, in our answer we disclaimed all right and title in the alleys adverse to the city, the existing alleys and the alleys themselves. We did not disclaim any interest with regard to the lots, the abutting lots. But
the city is currently the fee simple owner of the alleys, is that correct?
Yes, we have admitted that in our answer. That is correct. That occurred at the time of plat recordation. There's a dedication language on the plat. Back when it was in unincorporated territory, it went in trust to the county, and at such time that the city of Chandler incorporated, legal title vested in the city of Chandler.
And why doesn't that ownership provide the basis for the city's standing?
Because our claim we do not make a direct claim against those public alleys, nor can we, nor could anyone make a claim to those private alleys. We have no claim. They are trying to extinguish a claim we don't have. Our claim was made by contract. When Chandler Improvement Company sold the abutting lots, it reserved to itself the rights those abutting lots have. It says the rights in the bordering alleys and streets is the language that we use. So our claim is through the lots. It's by contract.
And talk to me, if I could move you to something of interest, talk to me about why that claim is not precluded based on this court's prior rulings in cases regarding the same subject matter.
The reason why they're not binding is because the real party in interest is not here asserting those claims. They're being asserted by the city of Chandler, who has absolutely no interest in the lots. My client's interest is in the lots. So what they're attempting to do is quiet title. If you look at the quiet title statute, it says quiet title to any adverse interest in the name of the person whose property is being affected by that. We do not have any adverse claim whatsoever to the alleys. Our claim is to the abutting lots. So we believe that this action is really, if there's going to be a future action to decide those rights, it would be between Chandler Improvement Company and the owners of those lots. The common law in Arizona clearly clearly supports a grantor when deeding property to a grantee, grants the right to reserve an interest, whatever it might be. In our case, our argument is our client reserved an interest in those properties to any interest in the bordering alleys that border those lots. That's the way it read. At the time those purchasers took title to those lots, there could have been no misunderstanding whatsoever that they would be able to later claim that they own any interest in those alleys upon reversion, contrary to Chandler Improvement Company's
this court already rejected that argument on the basis of those contracts?
Yes, they did. But what I'm suggesting to you, those are in different case. That was in a different case, and the reason why Chandler Improvement Company is bringing this matter, and the reason why they've agreed to do it, is because they have these certain defenses that they acquired through prior litigation, and yet those defenses do not, those claims, those claim preclusion and issue preclusion, do not belong to the abutting lot owners. That belongs to the City of Chandler. So the City of Chandler says, here, let me stand in your place, and I'll assert all these because I have these rights to assert. And also, it's our opinion, and again, I know that those are memorandum opinions, and that's what they are, and that those issues were decided. But what those courts said, and I think it ignores the real property law in the state of Arizona. It said that once there was a dedication of those alleys, Chandler Improvement Company thereafter had no right to reserve. They were reserving a future right in the event those alleys came back into ownership of those lot owners. And that's applicable law in the state of Arizona.
But the time to challenge those decisions has long since passed. Right? I mean, the mandate is issued, petition for review was sought by the Supreme Court.
That's correct.
That dust is settled. And right or wrong, we are asked to apply those for issue preclusion. Tell us why they shouldn't apply.
Okay. I beg your pardon for providing what I think is the answer here. Okay. And that is because issue preclusion doesn't belong to the real party in interest in this case. They're different parties. I shouldn't say they're not different parties. They should be different parties. What we are now claiming, that the City of Chandler has said we're going to now file a lawsuit that will extinguish any claim that Chandler Improvement Company has in the abutting lots. Okay. Now, that is not ripe in this case because by statute, those adjoining lot owners do not have any. They have a future claim, a potential reversionary claim, but currently they have no claim to ownership of those alleys because the vacation has not occurred. And under 287205, the legislature has made it extremely clear how this all works. And so what the City of Chandler is doing is trying to do kind of a preemptive move here. Whereas if they were to go ahead and vacate the alleys, and my understanding is they've sort of held that up for the time being, but had they vacated the alleys pursuant to statute, which they intend to do, we understand they intend to do that. If they do that, they have no interest in those alleys, whatever, to protect, preserve. There's no cloud and title. There's none of that stuff going on here because by statute and by case law, we have no interest in those alleys, nor does anybody else can claim any interest in those alleys unless and until they're vacated. So what they're doing as a precursor to the vacation of those alleys is to get this court to rule that we don't have that interest in those lots. And they're claiming that's issue preclusion because that was decided in the previous case. But that may only be raised, in all due respect, by the real party in interest, which is not the City of Chandler. They are here by proxy, attempting to insert issue preclusion and claim preclusion in a case that we don't have any interest in those alleys. We have no interest. They are trying to quiet title to our interest in the alleys, but indirectly, they're also trying to extinguish our claim in the abutting lots. What I'm suggesting again is that when you look at the standing issue we're raising, notwithstanding what these previous cases said, looking at the standing issue, they're like a stranger, if you will, to the real controversy that will come about if and when they vacate the alleys, because the state legislature says that's the way it goes. Then the state legislature also says that upon vacating those alleyways, then the title will vest in the abutting lot owners, subject to all the claims, interests, limitations, whatever there are existing at that time. So at that time, upon the vacation of the alleys, our reversionary interest comes to being. So the question I would have is, can the city of Chandler now decide that it wants to also, let's say there's a judgment lien against these lots, and that would interfere with this developer's right to go ahead and freely develop this property with a private residential apartment community. May the city of Chandler reach through the statute and eliminate that interest? I think the answer is pretty clear in the statute. So, and that's why I wanted to direct my comments to that. I'm not trying to avoid your question, but I hopefully I've answered, at least from our perspective. Pardon me, I'm looking to my notes. Now, upon vacation of the alleys, let's say that you make a determination that you're going to reverse and remand with a motion, with an order for the case to be dismissed because it's not in the name of the real party in interest. And by the way, we tried to get the real party in interest added to the case. It was opposed by the city, and the trial judge said that was moot. He wasn't going to go there. I disagree with that, but that's his decision. But in the event that, so if you were to send this back and dismiss it with prejudice, then we would have the current situation the way it is. Every title insurance company that's looked at this case, I'm giving you a little bit outside the record, I beg your pardon on that, but at least the title insurance company in this case has found that they're going to include in the title insurance policy an exception for the language contained in those deeds. And other title insurance companies on the other cases did the same thing. The title insurance industry recognizes this as a claim in the lots. We also had an expert opinion from John Graham, very capable lawyer who spent his entire career virtually here in Arizona from the state of Indiana, representing First American Title Insurance Company. He has a vast knowledge, understanding of that, and he opined that under these circumstances, it's an appropriate exception for a title insurer to enlist that and recognize it as a valid, lawful matter that has to be either disposed of or the title policy would be issued subject to that. So we've got the title insurance industry speaking the same thing.
Counsel, you agree that the dispute presented here is properly an issue of law for the court to decide that there's no factual dispute that needs to be resolved. Is that fair?
I would agree with that, Your Honor, yes. I mean, it's an application of the law and the law of standing. Who has the right to bring a lawsuit to quiet title Chandler Improvement Company's interest in these abutting lots? Who has the right to do that? And we would submit to you respectfully that the only party that could do that would be the owner of the lots themselves, who have taken title subject to those reservations and subject to an exception to coverage in their title insurance policies, which we have pointed out in our brief. Again, I stated, and I'm repeating myself, but in Arizona, it's black letter law that a grantor may reserve in a deed of conveyance an interest, a reversionary interest, and there's a whole variety of reversionary interests that may be asserted. I sort of try to go back to 1915 or 1916. back before title companies were in vogue, and back when all of the real estate transactions would have been handled by lawyers. And I came from the state of Ohio in the late 60s, and we did not have title insurers there. So we did all that ourselves. We did the closings in our office or at the bank if there was a bank involved, what have you. But some lawyer represented Chandler Improvement Company who would have drafted those reservations set forth in those deeds. That was all transactional way back then, very early days. But nevertheless, somebody took it upon herself or himself to insert that in the deed. All I'm saying is that's just part of the history here. But I agree, it's a matter of law. So what I request you to do is hold that the city of Chandler has no right to attempt to extinguish a private contract interest in private land to be developed by a private developer, private landowner. I respectfully request you to reverse Judge Talamonte's ruling. Send this back to the trial court. Order Judge Talamonte to dismiss the case with prejudice. So that issue's gone. And then, after that, D.C. Heights, the owner of the property, has the right to bring a cause of action against Chandler Improvement Company or vice versa with regard to those rights. That's the proper cauldron for this mix to take place. I will reserve the rest of my time. Thank you very much.
Good morning. Jenny Winkler on behalf of Appalachia City of Chandler. Chandler asked this court to affirm summary judgment quieting title to the alleys in Chandler. The trial court relied on facts and legal conclusions recited in 2 prior decisions of this court addressing these very same parties and this very same deed reservation. Twice this court has held that the 1912 dedication was a statutory dedication, that the dedication conveyed title in fee simple initially to the county and then later to Chandler when Chandler incorporated, that CIC did not hold title to the alleys and therefore could not reserve anything in those alleys when it conveyed the abutting lots, and that therefore CIC's deed reservations were of no effect. The city and CIC have litigated and relitigated the issue of CIC's deed reservation over the course of some 14 years. And multiple development projects in downtown Chandler have been hindered and delayed. And this current redevelopment project is just the latest example of that. And what has changed? What's different? Nothing, really. We have the same party, CIC. We have the same lawyer, and he's making all of the same arguments that this court has rejected twice. Notably, CIC doesn't even attempt really to address the issue preclusion or collateral estoppel issue other than to say, well, Chandler doesn't have standing here, so we don't get to that issue. And also challenges the ripeness. So I want to talk a little bit about the standing and actually the way that the Chandler's standing arises as the fee owner of the alleys. CIC's claim is creating a cloud on the title to those alleys. And Chandler is going to be in front of this court on this issue, whether DC Heights is in the case or not. And examples of how this works are apparent in the 2 prior decisions and also in the development agreement that is at issue in this matter. In the Chandler Unified School District case, Chandler and the district were cooperating in the expansion of the Chandler High campus in downtown Chandler. The Chandler and the district agreed that they were going to exchange some roadways and Chandler would vacate certain roadways. CIC's claim to those pops up in the title search. The district files a condemnation action against CIC and then finds out that in fact the issue of CIC's interest in the streets and alleys, that there is a concern with that. And so then the district brings Chandler in, okay? The project ends up tied up in litigation for 6 years. That's the Chandler Unified School District case. The second case, the Desert Viking case, almost identical facts to what we have here. It's a development agreement. Chandler and the developer are working on a project in downtown Chandler. The city is required to vacate portions of public streets and alleys pursuant to that development agreement. 6 months into the project, after the city has vacated, CIC sues the developer and Chandler. So it is somewhat disingenuous for CIC to claim now that Chandler is not a real party in interest here when it previously sued Chandler, and Chandler will get brought in yet again to this case. Both of those cases demonstrate that really the dispute is over title to the alleys, and it's between CIC and Chandler. And it's been relitigated twice all the way up to this court. The current, as far as standing in this case, the development agreement that is in the record, just on the face of that development agreement, it shows the injury to the citizens of Chandler that arises out of the cloud on title to the alleys. Again, it's a redevelopment project in downtown Chandler. The city is required to abandon these 2 alleys. The developer and the developer's bank require clear title to those alleys. The project has been in the works since 2012. It's expected to increase property values by 100%. It's going to assist in the revitalization of not just that property, but the entire downtown area. The citizens of Chandler have everything to lose here. CIC, a defunct corporation, actually has nothing to lose by continuing to pop up and press these meritless claims. The simple fact of the matter is that CIC's claim is precluded under the doctrine of collateral estoppel or issue preclusion. And the dispute is over the alleys. It's between Chandler and CIC. The developer is not a real party in interest. It's simply the party that is going to take title and ultimately from Chandler. And if Chandler doesn't convey clear title, the developer legitimately can come in and have a claim against Chandler at that point. Chandler asks that you affirm the trial court's finding of summary judgment. And unless you have...
I do have one technical question for you. I understand that there's a request for attorney's fees under Section 12-1103, which requires the city to have requested the quitclaim deed and the tender of the $5, and there's a dispute. Could you walk me through that statutory requirement, whether the city believes that statutory requirement was met for the purpose of attorney's fees?
I believe that statutory requirement was met. The city did tender a quitclaim deed and ask them to quitclaim title to the alleys. They declined to do so, and so we filed a quiet title action, and I believe that as a prevailing party, then we are entitled to a claim of we're entitled to our attorney's fees at that point. And I'm not sure what is there, what factual...
I understand the city made the assertion in the complaint that you tendered the $5 and requested the quiet title, but that's, as I understand it, CIC in response disputed that allegation.
And I think, if I remember correctly, I do not recall what the basis for CIC to dispute that was. I apologize. Perhaps Mr. Slavin can address that when he gets up here.
Okay.
If there's nothing else,
From the city's perspective, though, just to clarify, evidence of compliance with that statute would be found in your complaint and nowhere else.
I believe that's correct, yes.
Thank you.
At the outset, could I ask you to address this issue?
Yes.
What was the basis of the CIC dispute for that allegation?
CIC's dispute was we were concerned by sending back the quitclaim deed that the city of Chandler would claim that we also quitclaimed our interest that we hold through the abutting lots. So it was and you have to look at the letter and the way the letter was phrased. But we decided that we were not going to do that. However, in lieu of that, under ARS 121103, we disclaimed our interest at the outset. It says, if defendant or other than the state appears and disclaims all right and title adverse to the plaintiff, he shall recover his costs. That's what it says. The state legislature says that. In our answer.
Just to clarify, you're not disputing the fact that the city did, in fact, tender the quitclaim deed with the statutory fee.
That is, Judge Winstrup, that's correct. We do not dispute that, but what we did, in lieu of that deed, we disclaimed. And the statute allows us to disclaim, because we were concerned about what could be claimed under that quitclaim deed and the demand letter that went with it. I don't have the demand letter in front of me. We really need the demand letter to see what the context in which it was being presented to us. And I believe it was presented in the context that you have no claim, et cetera, et cetera.
And
So
your responsive disclaimer is in the record or not?
it is in our answer, Judge Stoma. Yes, it's in our answer.
Thank you.
Right off the bat, their first allegation is we hold the title of the alleys. We say you absolutely own fee simple title, absolute, to those alleys. But then we went on to defend the case.
Thank you.
So, since we disclaimed that, then we don't believe there's any claim for attorney's fees. And I think under the statute, the way it's literally read, we would have the right to have our costs. But they continued to dispute this case because they wanted it to make its way over to the lots adjoining the alleys and abutting the alleys, and to extinguish our claim in those lots by contract. By contract. That existed. And I, again, my argument is that the court, the prior courts probably did not get that right, because to make a determination that through contract that somehow the city that the courts can say if there is no interest there to reserve, it never said in those it never said that there's no reversionary interest in those lots. And that's the law in the state of Arizona. We have reversionary interest that can be done according to our statutes, our laws. So if the request by the city of Chandler is for this court to issue a ruling that my client has no current interest in the alleys, my client, that would be fine. My client does not have a current interest in those public alleys. It has a reversionary interest in the event that the vacation takes place, and there's the difference. Okay, but Chandler's attempting to do is to wipe out my client's contract interest, and I submit to you, no court in this land has a right to do that. And excuse me, no city in Arizona has the right to come in and do that unless they condemn it. But by quiet title, they can't do it. Thank you.
Thank you, counsel, for your arguments. Take the matter under advisement, issue our decision in due course. Court stands in recess.